How's everyone doing? Kevin here out of Massachusetts. Been a lot of confusion lately about um, CBD and is the CBD legal? I just like to go over a couple things and clear up some things with everyone about this certain DEA release that just came out saying that CBD is illegal. First of all, the DEA doesn't make laws; Congress does. Um, and second of all, they can sit there and say that CBD is illegal. However, they could never make all CBD illegal. That is because there's different kinds of CBD, basically the same thing, but based on where they come from, you can classify it in a certain way. So if CBD is derived from the marijuana plant, then yes, you're correct. It could be illegal. However, if CBD is derived from industrial hemp, then it is completely legal. So even though the CBD is the same thing from the industrial hemp plant or from the marijuana plant, based on where it comes from, it is considered legal or illegal depending on its source. So let me just go over a document with you to show you how if CBD is derived from hemp, it is completely 100% legal in all 50 states. I'm going to do this by bringing you guys over here to this law. This is for publication by the United States Court of Appeals for the Ninth Circuit. This is a case basically between hemp industries and the Drug Enforcement Administration. So when you go down into here, this is basically a case where the company Hemp Industries wanted to manufacture hemp-based products and sell them here in the United States. The appellant's business activities include importing and distributing sterilized hemp seed and oil and cake derived from hemp seed and manufactured for selling of food and cosmetic products made from hemp and hemp seed oil. So basically, this is what the company was doing, and the DEA stepped in and tried to ban their products, interpreting the listing of THC in Schedule 1. This rule would have banned the possession and sale of hemp industries products. So now they just say that we refer to hemp stalks, fiber, and cake made from hemp seed and sterilized seeds of hemp itself. Those substances excluded from the definition of marijuana under 21 U.S.C. Section 802 as non-psychoactive. A psychoactive substance is one affecting the mind or behavior. The non-psychoactive hemp used in the products is derived from industrial hemp plants grown in Canada and Europe. Their flowers contain only trace amounts of THC contained in marijuana varieties grown for psychoactive use. The hemp seed used in food products are in small amounts and are not intended for direct consumption in order to get high. And then they just went on to say that they're planning a wide range of products from hemp seed oil, including nutrition bars, chips, pretzels, beer, sauces, dressings, and non-dairy versions of milk and cheese. So they had big plans for this hemp products here. So, we're just going to skip through most of the mumbo jumbo here, and we're just going to go down to what the final ruling of the court was here. So, although we have determined that non-psychoactive hemp is not banned under Schedule 1, we need not determine if this proceeding, whether the current statute, it could be listed if the agency were to undertake appropriate rulemaking. We hold only that the DEA did not follow the requisite proceedings for scheduling under 21 U.S.C. And the final rule therefore may be enforced with. The DEA argues that because hemp seed contains some THC, we should allow it to include hemp seeds and its derivative as within the exception to the exception for the extraction of resin. Neither we nor the DEA are in any position to ignore the express exception for hemp seeds in the CSA, nor can we constitute resin broadly mean seed as well. As the DEA informs us, the exception to the exception for resin was apparently included out of the concern for the active principle in marijuana, later understood to be THC. The final rule purports to regulate foodstuff containing natural and synthetic THC, and so they can, in keeping with the definition of the controlled substance under Schedule 1 of the CSA, the final rule can regulate foodstuff containing natural THC if it is contained within marijuana, and can regulate synthetic THC of any kind, but they cannot regulate naturally occurring THC not contained within or derived from marijuana. Non-psychoactive hemp products, because non-psychoactive hemp is not included in the Schedule 1, the DEA has no authority to regulate drugs that are not scheduled, and it has not followed procedures to required to schedule the substances. So basically, this is saying the DEA cannot regulate substances that are not part of the scheduling. Therefore, all parts of the cannabis plant from hemp are void from their regulation, and they grant the company, the hemp company, petition to permanently enjoin enforcement of the final rules with respect to non-psychoactive hemp or products containing it. So basically, the court said that they permanently rule that hemp or any products derived from hemp are completely legal, and this is their final decision with respect to non-psychoactive hemp. So I hope you guys enjoyed my little education on the subject.